Test. Testing. Testing 3. Testing 2. And good afternoon. You can be seated. The matter before the court is Cumberland 2529, Emily Bickford versus Matthew Bradeen. We are being streamed on the web, both by audio and by video. I see counsel are present. I'm assuming ready to proceed. I would ask counsel who are arguing here this morning to introduce themselves for the record, together with the party you represent, starting with the appellant.
Good morning. Matthew Staver on behalf of Emily Bickford.
Good afternoon. Michelle King here on behalf of Matthew Bradeen.
Thank you. And counsel, if you're ready to proceed, we'd be happy to hear your argument, Mr. Staver.
Madam Chief Justice, and may it please the court, the order below should be reversed because it violates the First and 14th Amendments. It cannot survive the compelling interest test, which the judge below purported to apply, and which the appellee does not contest as the correct standard. In this particular case, there is no finding of abuse or neglect. In fact, what we have is a fit parent. A fit parent is presumed to act in the best interest of their child. There's no immediate or substantial harm that is shown. In fact, the respondent's brief, or the appellee's brief in page 27, purports to suggest that there's compelling interest, and they put forth only 5 things. Number one, that Ava at one time was observed to have anxiety, that she had an observance of a panic attack, that she had questions, that she put notes around the house, and that on one occasion she put in a workbook that this demon image was scary. That's all that they have as far as a compelling interest test. That cannot be a compelling interest, and it cannot amount to immediate and substantial harm, justifying this drastic change and taking away from a fit parent the right to the religious education of their child. Not only does it not survive the compelling interest test, but it cannot survive the least restrictive means. In fact, on page 34 to 35, only 1 1/4 pages of the entire appellee's brief is dedicated to trying to justify and defend the least restrictive means, or narrow tailoring. And there's nothing there that is in that 1 1/4 page that suggests narrow tailoring. In fact, the appellee's brief essentially concedes that a total ban on worship would not survive strict scrutiny. But they suggest that what is here is not a total ban, it's just a ban totally with regards to Calvary Chapel, which we'll talk about later. But it is a total ban because under Calvary Chapel and all the things associated with it, including the people that attend Calvary Chapel, also applies to any other church or religious organization. Mr. Bradeen has absolute, unreviewable authority to deny any kind of association or even reading the Bible or religious philosophy, attending any church or any event, or associating with anyone, particularly Calvary Chapel, but associating with anyone or any church or religious organization. That is so breathtakingly broad, it cannot stand narrow tailoring, and neither do they attempt to even defend that, because they suggest that it only applies to Calvary, but what applies to Calvary is the total discretion in one individual to take away the religious upbringing decisions of a fit parent, and that also applies to any church or religious organization, which could be, for example, the Salvation Army or the YMCA or a food bank or a homeless shelter. This is so breathtakingly broad, it cannot, under any circumstances, survive narrow tailoring. I welcome the questions of the court.
I see that the green light is on, so well-timed, counsel. You agree that 19A MRSA Section 1653 permits the court to allocate decision-making on really any matters with regard to the child as between the parents. Do you agree with that?
Yes.
And you have suggested that this order, which does that in accordance with statute, must be that the decision to allocate decision-making as to religious upbringing or religious education as between the parents must be judged under a compelling interest, that there's strict scrutiny. That's your
correct,
position.
yes.
And you have indicated that Mr. Bradeen doesn't contest that that is the correct standard.
Correct.
But we're not bound by that, are we?
No, you're not bound by that, but that is the standard. Certainly, the standard here, when you have a...
I understand it's your position that that's the standard here, but isn't it true that in this case, each parent has the equal right before the court makes the decision in this case, both parents stand equally in being able to control the religious and educate the child in religious matters.
That's correct.
And
But
so it is not a matter, I mean, to the extent one parent takes greater control, if you will, over that, away from the other parent, that is in derogation of the other parent's rights.
you might have minor differences in terms of what they're going to be doing in terms of allocation, but this particular order doesn't do that. This particular order vests total discretion into one parent and takes away total discretion and decisions from a fit parent. In
Well,
fact,
what's the test? I know this is not this case, but what's the test when first allocating, one parent wants religious upbringing as one religion, the other one wants a different religion, and they've both shown they can't cooperate on this issue. What's the test the court is supposed to do in allocating?
Let's assume it was the original order.
yeah, the test would be still the compelling interest test. And
But they both
narrow tailoring.
have equal interests, don't
But
they?
one parent can't have a total veto over the religious education of the other. There may be circumstances.
But this
for
wasn't a total veto.
It is a total veto. In fact, since December of 2024, it's operated as a total veto. There's been no
The
association.
language of the order, and obviously whatever has happened since then has not before us, but the language of the order is not a total veto.
It is a total veto, respectfully. It says, for example, that Mr. Bradeen has allocated the right and responsibility to make decisions regarding anything related to Calvary Chapel in terms of any attendance, services, gatherings, events, anything associated with Calvary Chapel, any material, literature, video, or other
Right.
messaging associated
But there is
with.
no veto over the interactions that Ms. Bickford may have with their child.
Well, not with the child, but with regards to the religious education, there is.
I assume she engages her child on religious matters as well as other matters.
No. In fact, she is abiding by the order because the order gives a specific absolute veto to Mr. Bradeen. And though it's not in the record, Mr. Bradeen has not given any consent to anything, to any church or any organization, despite her request. And that's exactly how the order is designed to operate. It's operating exactly how it was designed, to give total authority into Mr. Bradeen, and it relates as it relates to other churches or religious organizations. So it's not just limited to churches, that he has the right to make a final decision as to whether she can read the Bible or be introduced or associated with or in any contact with religious philosophy, whatever that is.
Is there a tension between the best interest of the child standard that we use and freedom of religion? Are those two things in tension?
They're not in tension. I think when you have a case like this, and the court order below actually acknowledged that this was a religious sensitive situation and therefore the reason for the compelling interest test. And when you have a religious sensitive issue, you've got this court in the Ossier case finding that there's no narrow tailoring. You've got the Harris case with regards to snake handling at the Mississippi Supreme Court, where the child was introduced to a snake handling church, and it was very disturbing emotionally, and yet the one parent said, I want to have a veto over that particular type of exposure to religious activity. The court in Mississippi said, no, you can't have a total veto
So
over the other parent.
to respect each parent's rights, would the result be that when the child is with the mother gets to decide, and when the child is with the father gets to decide?
Absolutely. The duality of competing religious ideas or even irreligion versus religion is something that courts have countenance and
Well, you
dealt
seem to
with.
be suggesting then that to the extent 1653 gives the court the right to allocate that decision-making to one parent over the other, so long as it is in the best interest of the child, is invalid.
I would say that it's not invalid per se, but I would say that it cannot cannot be allocated totally to one parent. It has to be dual decision-making. And how the courts, for example, in Kingston, the Utah court, this was a polygamous situation where they were grooming, the allegation was that they were grooming children to be child brides.
So, counsel, where is the line? Is there any line in your mind as to, let's say the allegation is that a particular practice or sect is causing harm to a child? Is there any line at all, or is it?
There's certainly, Your Honor.
What is it? Where's the line that you would draw?
There would be a physical, like if somebody were being sexually abused in a particular church, no question about that, that would be something. But in this case,
Short
there's
of
two
that?
places, and I'd like to point out
Anything,
page 42.
anything short of that?
Well, let me look at this particular case, appendix page 42. This is the order. This is the order, and it says that there's no showing of harm.
I know, I understand that. But I'm asking you where you draw the line. Is it just at physical abuse or sexual abuse? Is that where you draw the line?
I think it certainly would be at that, but
Anything
it's certainly
beyond
not at the clashing of different ideas or different religious
No,
ideas.
where do you draw the line?
Well, I would draw the line the way the courts have drawn the line. For example, in the snake handling church, there was a possibility that she could have been bitten, but they said you can't prohibit that. In the case with the order, where they were being groomed allegedly for being a child bride, you can't totally prohibit that either. One
So let me
parent
just
can't
get
have
this
the
straight.
total veto.
Going back to the snake handling case, if it were a poisonous snake that was part of the regimen of that particular religion, you're saying that the court cannot issue an order in light of the child being exposed to being bitten by a poisonous snake?
These were poisonous snakes, Your Honor, and it was the Mississippi Supreme Court that actually made that ruling. It was a snake handling church, a free will type of church, where they were bringing up poisonous snakes, and that's what they do. There was no evidence that the evidence was that the child was in the midst of that. The evidence was that the child saw all of this activity going on, that it could be psychologically disturbing.
But here, counsel, we have a finding. I understand you disagree with it, but we have a finding from the trial court. There has been harm, in particular that the child is suffering from anxiety and panic attacks. So it's not speculative, but assuming we were to credit that finding, your position is that still the court has no authority to allocate decision-making to prevent that sort of harm?
Correct. I don't think I can credit that finding for a couple of reasons, but even if you
I
did...
understand that, but if we did...
Even if you did, that is not sufficient. What we have in the record is one occasion where Mr. Bradeen allegedly said he saw her being anxious. On one occasion, he says, and we're talking about since May of 2021, on one occasion, he saw her having a panic attack. He saw her putting down notes in the house, and he saw her write that she was scared of a demon image in a workbook. That
Counsel,
cannot be the harm that is necessary for one person to have a veto over the other parent's right, especially a fit parent.
I'm going to exercise the chief's prerogative, and I do want to ask one more question before you sit down. Let's assume, just assume, that we disagree with you that this has to be analyzed under a compelling interest and strict scrutiny standard, and rather, it is a simple question of what allocation of parental rights in the best, if it is in the best interest of the child. The judge here, after finding that applying a strict scrutiny and finding harm, then also applied best interest factors under Section 1653 of Title 19A. If we think that is sufficient, i.e. to analyze it under a best interest standard, having in mind that a court would certainly need to be neutral on judging the merits of one religion over another, do we have to remand, or would we simply affirm the best interest analysis if we thought it was supported by the facts?
I think you would have to remand at a minimum. And putting aside the compelling interest test, I don't think that the best interest of the child would actually pass in this particular case for several reasons. One, page 42 of the appendix, no showing of harm with regards to introduction of any religion relative to the Bible.
No, the
Two,
harm was that the court found, I think, was centered on the inability to co-parent and the denigration of the other parent.
well, she didn't denigrate the parent.
But she allowed others to
Well,
in the
that's a
presence.
simple fix. You talk about, are there different parameters?
Okay.
You don't talk about the other.
So getting back to the one question that I wanted to ask, that you think that it has to be vacated and remanded, even if we think it's a different test, that the best interest analysis that was done here is not supported or is not sufficient?
It's not supported and it's not sufficient. It's not supported because she's already indicated in the area of religion there's no harm. In the area of medical decisions, there's no intended harm and there's no consequential harm there as well.
Okay.
And she also indicated that there would be significant harm to the minor, Ava, having been in connection with Calvary Chapel for years, having grown up with friends for several years, to simply just cold turkey stop that. And that's what the order did. It completely disconnected her to Calvary.
Thank you,
that can't
counsel.
be in the best interest of the child.
Thank you. Attorney King?
Good afternoon, and may it please the court. Recognizing that this was not a case where the issue of religion could be easily divorced from the issue of parental rights and responsibilities, because it was exposure to the religion itself and the mother's poor choices that flowed from her beliefs that were causing the documented harm to the child, the lower court fashioned an order that followed this court's roadmap and Osier. The lower court set forth a strict scrutiny analysis, finding two compelling state interests. First, preventing further harm to the child and maintaining the child's best interest and well-being, and narrowly tailored an order to achieve that result. What is often difficult in cases filled with rhetoric and bluster is how to address inaccuracies of fact and misinterpretation of law. This case presents such a challenge. My time here today could be filled with answering all of them, but it's important to highlight three. Ms. Bickford repeatedly characterizes the lower court's specific finding that it was objectively inappropriate for the child to hear the sermon on August 28th as a finding that all general prayer is objectively inappropriate. That's simply not true. The court found that the particular sermon that highlighted the custody battle between the parents, that specifically named them, that cast their battle as one of good versus evil, that disparaged the dad as the enemy, with the child in attendance, was objectively inappropriate. Second, Dr. Lalich is not a so-called expert. She was a stipulated, designated expert at trial. Disagreeing with her opinion does not make her less of an expert. Third, when religious freedoms of a parent are involved, the line of demarcation between religious rights and orders on parental rights and responsibilities is harm to the child. When harm is demonstrated, especially manifested harm, as here, an order may be entered that limits the religious rights of the parents. No cases state otherwise. The mandate of the Parental Rights and Responsibility Statute is the consideration of the safety and well-being of the child, the best interest of the child, not the parent. It specifically contemplates orders involving religious upbringing. The lower court's finding that the child was actually harmed by her exposure to the teachings and contents of sermons from Calvary Chapel was well supported in the record and is afforded broad discretion. To rule that the child's well-being should be ignored in light of this documented harm in favor of the mom's religion would fly against our statute, our case law from across the country, and would give any religion unfettered exposure to children regardless of their well-being, contrary to the safeguards in place to protect our most vulnerable. This court should uphold the lower court's narrow decision awarding the dad allocated decision-making over the child's participation in Calvary Chapel and shared final decision-making on medical decisions and other religious decisions.
Well, let's assume that, hypothetically, we change from strict scrutiny to a test that looks to the best interests of the child as long as there's no hostility shown to either parent's religion. Is it your position that this decision doesn't show hostility to the mother's religion?
That's absolutely my position, Your Honor. This decision was very well reasoned. It was grounded in fact. It talked about specific experiences.
Doesn't it kind of reference the mother's religion as a cult?
Well, the judge didn't make a finding that the mother's religion was a cult. She made a finding that that's what the expert found. When you look at what the judge actually relied upon in making her decision, nowhere does she call the religion a cult, nor does she rely upon that finding in making her conclusions.
If the test is, as Justice Connors just said, not one of strict scrutiny, but rather best interest ensuring that there's no hostility demonstrated, if we agree that that is the test, but that's not the test that was applied here.
Correct, Your Honor.
So do we have to vacate?
We don't have to vacate because the judge's findings also went through, in the course of going through the compelling state interest and strict scrutiny argument, the judge did do a best interest analysis, not only on the religious component, but on the medical decision-making component, and made specific findings as to why an allocated decision-making with regard to Calvary Chapel was necessary and why shared with final decision-making to Mr. Bradeen was necessary for medical decision-making.
So you think it's sufficient analysis that it doesn't need to be redone because it's essentially, she applied a higher standard and engaged in a full best interest analysis?
I do, Your Honor, because if you look at
But isn't there a fair amount, I mean, as Justice Connor said, isn't there a fair amount of hostility in the order with regard to the specific religion?
Again, Your Honor, you have to look at how the judge laid out the facts. She laid out the facts and her findings of fact according to the testimony of Dr. Lalich, certainly. But when you look at her application of the facts and her conclusion, I would suggest to you that no, there's not hostility as it comes out in her conclusions. It was incredibly well-reasoned and followed.
What if we find, counsel, that there is hostility or that the order doesn't convey the type of neutrality that's required? Would we have to remand in that instance, or is your argument that that could somehow be disentangled from the best interest analysis that the court performed?
I would suggest that it certainly could be disentangled, Your Honor, because the judge did exactly what the statute required of her. In fact, the judge went above and beyond what the statute required of her by doing a strict scrutiny analysis. And I cited in my brief a couple of cases, in fact, from across the country that talked about parental rights and responsibilities where you don't have to do a strict scrutiny analysis. Nonetheless, the court in this case chose to follow the higher path, thinking that under Osier, where this court had set forth a strict scrutiny analysis, that should be followed, even though Osier was a custody case. In this case is a parental rights and responsibilities case.
But in this case, the court issued a total prerogative to the father to make the decision, basically, effectively a veto, as it was described earlier. It's not in the scale of things that can be done. That's kind of the nuclear option. It's the far end of it. Was that overkill? Did the court go beyond what the facts here would justify? Stated alternately, was there a less severe scenario that could address the concerns about the child's welfare other than giving one party full and final prerogative to make these decisions?
Well, hypothetically, Your Honor, that could be done. In this case, however, the court was very clear that it was the particular thing that this church was doing. And so there was a court order, in fact, that neither party could disparage the other parent or could allow a third party to do so. And yet, Ms. Bickford allowed the child to go in to Calvary Chapel and listen to a sermon that disparaged her father, cast him as...
But did she know ahead of time?
She did know ahead of time, Your Honor, that there was going to be discussion about the custody battle on that particular night. Once it went off the rails, she let her daughter sit there and listen to the discussion disparaging the father and talking about good versus evil. And so it's that, and the mother's testimony...
Let's focus on that last point, good versus evil. I mean, you could read this as saying what's making the child anxious is that the religion of the mother is saying that because the father doesn't share that religion, that there are going to be consequences for him after life. And it says so in a very animated way. If we say that's as compared to another religion that is less aggressive in those tones, we can't decide, well, then that one's better than the other, just because perhaps the child's getting a little anxious at the demonology language, because then aren't we judging the religion itself? And we're not supposed to do that, are we? And if we did, there'd be an awful lot of religions that would then not be considered in the best interest of the child.
Well, again, Your Honor, we're not talking about a little bit of anxiety. We're talking about a panic attack, which is a very big manifestation of anxiety for a young kid. And so that's a specific harm. It's not something that's out in the future or something that's making her feel a little bit uncomfortable. Courts across the country, and this court has said on a number of occasions that exposure to this type of conflict is terrible for kids. And now we have a young girl, 11 years old, sitting in church listening to a sermon that is talking about her parents being in a battle against each other and how her father is trying to prevent her from salvation.
It's your view that this order is founded not upon a religious hostility, but rather that essentially the mother's religious schooling or beliefs is creating an emotional minefield for the child in her relationship with the father.
It is causing harm to the child. It is causing documented panic attack harms to the child.
I guess I'm struggling with, though, your assertion that there's no hostility at all, or that the order is entirely neutral when it comes to the mother's religious beliefs. I mean, for example, there's language about how some of the sermons preach, I think the language used was sort of hateful or offensive rhetoric. I mean, hasn't the United States Supreme Court told us, for example, in Masterpiece Cake Shop, that it's not for the courts to decide what sort of what's offensive within a religion, that's not an exercise we should be engaging in? And it looks to me like the court below did some of that here.
Again, Your Honor, the line is not what's said, but the impact on the child. In this case, the impact was specific and named.
But how do we know that the court's analysis of the impact wasn't informed by what appears to be a lack of neutrality in evaluating sort of the religious beliefs of these two different parents?
Well, again, Your Honor, I think it is clear because the judge went through first off the best interest factors and talked about them and weighed them all out specifically. And if there was language in there, so if you look at, there's one case, I think it's Funk v. Osman, but I could be wrong, that talks about some of the similar language here, tricks and snares and such things. And the court said that language of that type can be harmful to a child. And if there is manifested harm to the child, that's where the line has to be drawn. And so while some of the language may seem hostile, I would suggest to you that, again, it's all grounded in fact. It's grounded in fact that's documented in the record, that is supported by the expert in this case, and is supported by the child's writing in her religious notebook that this is scary because of the demon. She's obviously affected by it.
You would agree with me that in this particular instance that the court did a straight best interest of the child analysis with respect to the allocation of medical rights, correct?
Yes,
or
I would.
Medical decision-making.
Yes, I would.
So there was no overlay of any type of strict scrutiny there, did not pertain.
No, Your Honor. The judge made a finding that Ms. Bickford's medical decisions were not religiously related, and in fact, Ms. Bickford testified that her, at least as to the COVID vaccination, that wasn't based in any religious belief.
So might we infer with the way that the allocation of rights with respect to medical decisions might suggest that there was some hostility with respect to the allocation of decision-making about religious issues? Because I note that with respect to the allocation of medical decision-making, that the father is required to consult with them. They have diametrically, it seems, pointedly departure between their views of how medications are supposed to be applied or what types of vaccinations should be afforded the child, which could have a direct negative impact upon the child's well-being. Notwithstanding that, in that circumstance, the court requires the father to consult with the mother with respect to making final decisions or before he makes final decisions. So does that suggest that there is something more in the way of antipathy that was directed towards the decision in the context of religious decision-making?
No, Your Honor. In fact, the part of the judge's order that talked about other religions other than Calvary Chapel also was the same order as with medical decision-making. The parties have to have a discussion about the religion, but in the end, if they can't agree, as per our statute, Mr. Bradeen was given final decision-making. The reason why allocated was so necessary with regard to Calvary Chapel is that Ms. Bickford testified that she wouldn't follow a court order. There was a finding that Ms. Bickford did not consult with Mr. Bradeen about Calvary Chapel. In fact, she was short of lying, but had told Mr. Bradeen at one point that they were simply going to the Capitol when they were going for a abortion rally. There were a number of findings, and there was also a finding.
Can I ask you in the 40 seconds you have remaining here, if the evidence indicated, not necessarily in this case, that the practices of the church did not result in harm that was manifested in the child, that would not, that doesn't tip the scales. Is harm to the child the touchstone of this?
It is, Your Honor.
If the harm to the child is de minimis, just a sort of a minor thing that the child cried on one occasion, would that still justify an order giving the veto prerogative to one of the parents?
No, Your Honor, and there are a
So
number of
it's a
cases
scale?
that talk about that. There are a couple of cases that talk about anxiety that causes bedwetting, for example. And so it has to be some kind of manifestation or something that's severe. But the courts also say that we don't have to wait for it to be so severe that a child, suffers irreparable emotional harm. And in this case, much like a case where a child has anxiety and then soils himself, the child in this case had a manifested reaction to her anxiety, which was a panic attack, which are quite severe, especially in young children.
Thank you, counsel.
Thank you.
And Attorney Staver, you've reserved 3 minutes for rebuttal.
Compelling interest test has to apply in this case because of the hostility that's evident on the face of this order. I've never seen in the history of my career an order as hostile as this one, that intentionally every time God is mentioned, lowercase is God. That started with Matthew Bradeen when he issued his original complaint, he lowercase God. But unfortunately, that same hostility is evident throughout this order. Appellee understands the difference between uppercase and lowercase because in their brief, when they actually quote the order, they misquote it. They actually use the capital G instead of the lowercase g. Anyone knows that when you do a capital G, it's talking about a supreme being, a specific one that she believes in as a supreme being. But when you do a lowercase g, it's not monotheism, it's polytheism. That's an assault to both Christianity and Judaism and Islam. And that's what this order does. And that order reeks with that kind of hostility by intentionally doing that. I've never seen that before. But in addition to that, it bleeds over to this idea that this church is harmful. This is an evangelical mainline Protestant church. What's harmful? They haven't really said. Exposure to heaven and hell, demons, salvation.
Well,
and
counsel,
afterlife?
didn't the judge really ground her decision in the end, and not putting aside some of the other language, into the fact that what the mother was doing is basically exposing the child or into, as I said, denigrating or putting down and concerning the father, and that in our best interest, the ability to support the other parent as an equal parent in the child's eyes is critical.
But that's one instance. It's not a sermon as Amarylis suggested. It was a spontaneous prayer that Emily Bickford did not know was coming.
That went on for quite a while.
It's listed verbatim, and it's misrepresented by the judge by saying, well, he was saying that he's the enemy. That's not what he says. It mentions good and evil. That's not what it says. And that's one instance. That one instance, or one instance of panic with no evidence that you need a counselor, as Mr. Bradeen does not believe there's a counselor needed, that cannot be the harm sufficient to justify this extreme shift of a fit parent's right to raise their children in a religious environment. And that's what this order does. And consequently, it should be reversed under the compelling interest test, but it should be reversed under any consideration because it goes far beyond what is necessary because what they do to Calvary Chapel is the same thing that applies to any other church. There's no difference in the kinds of things that are taught. And other courts have clearly indicated this is not narrow tailoring. It can't be when you vest total discretion of a veto power over all religious decisions, including communicating with previous people you knew, in one parent.
Thank you, counsel. Thank you for your presentations here today, counsel. As is our usual practice, we will be taking this matter under advisement and issuing a written decision in due course. And with that, we will be in recess on this matter. afternoon. You can be seated. The matter before the court is York 24-355 regarding the child of Danielle H. We are being streamed on the web in this matter, both by video and by audio. I see counsel are present. I'm going to ask that you introduce yourselves by saying your names for the record together with the party you represent, starting with the appellant.
Good afternoon, Your Honor. Sarah Murphy on behalf of the appellant, Danielle H.
AAG Hunter Humphrey for DHHS.
Thank you. And Attorney Murphy, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Your Honor. May it please the court, again, Sarah Murphy on behalf of the appellant, Danielle H., who is also present in the courtroom with me today. Under Maine law, the paramount consideration in any proceeding affecting a parent's rights is the child's best interest. Title 22, Section 4005, and the entire child protective statutory scheme creates a role for the guardian ad litem that is not ceremonial, but essential to enable the court to reach an informed, constitutionally sound decision given the fundamental rights at stake in these proceedings. Specifically, Section 4005 requires that a guardian ad litem investigate, represent, and provide a recommendation to the court regarding the child's best interests. Now, those requirements are not disjunctive or permissive. Instead, the statute's text is mandatory. The GAL shall investigate. The GAL shall report to the parties and to the court. And the GAL shall meet with the child and other relevant persons to discern the child's best interests, including the best permanency option in any given circumstance. Now, that statutory mandate reflects legislative recognition that children are vulnerable parties whose perspectives and needs cannot reliably be presented either by the adversarial parties alone or by the court alone. The GAL failed in that statutory directive in this case. The GAL's investigation was legally and facially deficient, requiring vacatur of the mother's termination order. The guardian never observed the mother with the child, thus was wholly unable to investigate her ability to parent or the child's attachment to his mother. The guardian did not review the records of the mother's medical providers or substance abuse treatment providers. The guardian never met the mother face-to-face during the pendency of this proceeding. The guardian missed nearly half of the family team meetings in this matter. And the guardian filed one report, which was prepared not for the mother's termination hearing, but for the father's jeopardy hearing, which was scheduled in February of 2024, months before the mother's termination trial in this matter. Without a sufficient investigation by the guardian, the record before the trial court lacked critical information about the mother's parenting capabilities, the child's attachment to the mother, the child's adaptability and needs, feasible reunification services and the timing for completion of those services, or less drastic permanency alternatives like a permanency guardianship that could better serve the child's long-term best interests. Absent such an investigation and corollary informed recommendation to the court, the TPR order cannot stand. As such, I respectfully urge this court to vacate the termination order of the district court and remand this matter for further proceedings. And at this time, I'd be happy to answer the court's questions, though I'm also fully prepared to go into further detail regarding the deficiencies of the TPR
Well, the green
order.
light is on, so well timed.
Yes, Chief Justice.
So talking about the guardian, since that's where you started, let's assume we agree with you that the guardian completely, did not abide by the obligations that a guardian ad litem has in this case, that the investigation was inadequate, that any basis for an opinion may have been inadequate as well. Was there any objection below? Was it brought to the attention of the court in any fashion?
I don't think it needed to be, Your Honor. I think that the guardian, given the legislative mandate, needed to fulfill the obligations of the court and the statute in order. I don't think it was on the parent's attorney to make any type of objection.
The guardian was at the hearing?
The guardian was at the termination hearing, yes, Your Honor.
And subject to cross-examination, the fire of cross-examination, as it is said, to test the underpinnings of any opinion in this case?
Yes, Your Honor, but again, I do not think that that is a substitute for given the fundamental rights at stake in these proceedings, that is not an adequate substitute given the mandate of Section 4005 and the court obligations based on the guardian's appointment order from the court.
Did the court rely on the guardian's opinion in this case?
We don't know if the court relied on the guardian's opinion in this case.
There's no expression that the court was relying on the guardian's opinion.
No, but to make a best interest determination, because the guardian is required in child protective proceedings, the court cannot make a best interest determination absent the recommendation from the guardian, which is based on a thorough, robust investigation into the child's best interests. That is why the guardian ad litem is required in child protective proceedings as opposed to being permissive in other proceedings. You have to have that unbiased, objective opinion in these proceedings.
So is it your view that if the guardian has not abided by all of the statutory obligations, the court simply cannot proceed?
I think that there is a line, a threshold under which, so for example, if there has been, the guardian has not met with the child has met with the child throughout the case, but in one instance met with the child in a 4-month increment as opposed to a 3-month increment, which is outside the bounds of the statute. That, Your Honor, I would not suggest to the court that means that the court cannot make a best interest determination. What we are suggesting here, which has never been brought to the court's attention, that the guardian's charge in this matter was so deficient as to render this situation that the guardian was a nullity, that there essentially was no guardian in this case.
So let's start there. Let's subtract the guardian's report. Let's take all of it out of the record. The court had testimony and evidence from other witnesses. The court made findings. Shouldn't we look at those findings to determine whether, A, they're supported by the evidence, and B, whether they add up to both a fitness determination and a best interest determination?
For the fitness determination, I'll put that to the side for a moment, Your Honor, but for the best interest determination, I think it's unfair to suggest that the court does not look to the guardian for a recommendation when coming to their decision. Trial courts, when they're in these proceedings, rely heavily on the guardian's investigation and the recommendation of the guardian.
Some rely on it more than others.
Fair enough, Your Honor, and I know that you have firsthand experience in that realm. But I do think that it's essential to recognize, and for this court to recognize, that there is additional weight given to the guardian's opinion in these matters.
There's no question the guardian plays a valuable role in this process, an essential role, I would say. But is it absolutely necessary?
Yes.
And if there's a record that supports the court's decision, apart from any input from a guardian, don't we defer to those findings?
No, Your Honor. Given the legislative mandate in 4005, if the guardian had witnessed the mother with the child, there's other testimony in the record, including from one of the department's own witnesses, one of the supervisors, regarding how much the child and the mother had a bond, how the child would light up when the mother would enter the room, how he would reach for her when she would walk into the room. Had the guardian witnessed the child and the mother together and been able to testify regarding the bond between the mother and the child, the attachment that the child had to the mother, her parenting capabilities, that absolutely could have swayed the court's determination in this case.
The mother would have been able to put in that evidence independently. It isn't like the fact that the guardian didn't tell the court. She could have put that in from other sources.
But again, the reason that 4005 exists, Your Honor, is because that presentation from the adversarial parties is not sufficient when we're talking about a best interest of the child determination.
Well, it's not that it's not sufficient. It would be better if we had. I mean, it's not necessarily legally insufficient.
Well, I'm submitting to the court that I believe it is legally insufficient.
Are you aware of any authority that backs that up?
There's no, 4005 backs that up. There is no fewer than 7 shalls.
Any of our case law that backs that up?
There's no case law that suggests otherwise, Your Honor. There are 2 cases cited by the department. There's In re McKenzie, where there was 4 guardian ad litem reports over a very long period of time, and 1 report was excluded because the time elapsed between when the child had been seen by the guardian was outside of the 3-month period. Again, that is a situation where there's nothing else in In re McKenzie to suggest that the guardian's investigation was so deficient that the court was unable to make a determination.
So what is the court to do? You show up for the termination hearing. Let's assume, which didn't happen in this case, that the parent or parents says this guardian report is, woefully insufficient, and let's assume it is. In other words, that the guardian didn't observe the parent didn't meet with the child, all the things that the guardian has to do. At that point, let's assume, you've got a child that's been in care for far longer than 15 months, let's just assume. What is the court supposed to do? I mean, isn't there a tension in that statute? I understand what you're saying about the necessity and the importance of the guardian, and we can agree that that is important. But the statute also makes clear that we don't want children caught in foster care drift, and that we need to deal with these issues in at least a reasonably expeditious manner.
Agreed, Your Honor. So I want to let me take you to that point for a moment. In this case, there's been a lot of talk about this child needs permanency now. The mother may be months away from being in recovery or being able to parent this child. And there's a lot of language suggesting, the legislature has spoken in days and months and not in years, as may better befit a parent's recovery. This petition was not filed on the end of the 15th month under Section 4052. There were months available to this mother to continue in her reunification and rehabilitation.
Well, let me take you to Section 4055, subsection 1AC, that the court may presume a parent is unable or unwilling to protect a child from jeopardy and the circumstances are unlikely to change within a time reasonably calculated to meet the child's needs if the child has been placed in the legal custody or care of the department, the parent has a chronic substance use disorder, and the parent's prognosis indicates the child will not be able to return to the custody within a reasonable period of time, considering the child's age and need for a permanent home. And more specifically, the fact that a parent has been unable to provide a safe care of a child for a period of 9 months due to substance use constitutes a chronic substance use disorder.
And yet, at the time of this termination trial, Your Honor, the mother was about to approach her 1 year of sobriety, had been engaged in the Enzo house, had found her sort of substance use match, so to speak, was on a path toward really getting her life back.
Are you suggesting she did not have a chronic substance use disorder?
I'm not suggesting that, Your Honor. I think I'm not a medical expert, and that wasn't put into the record, but she certainly had a long-standing struggle with substance abuse, and I'm not...
Isn't your issue on that, and you've kind of raised that question too, that it's inconsistent here with what we know about recovery, but that's really a statutory change that would have to be recognized, isn't it?
I do, but I also... May I answer that question, Your Honor? I also believe that this underpins the necessity for a thorough and robust guardian investigation, which includes reviewing how the mother is doing in pursuit of her sobriety. Thank you, Your Honor.
Attorney Humphrey.
Good afternoon, Chief Justice Stanfill, Associate Justices, may it please the Court. The legislature's express intent in providing a process for the termination of parental rights was to, quote, eliminate the need for children to wait unreasonable periods of time for their parents to correct the conditions which prevent their return to the family. In this particular case, the child entered state custody the day that he was born, affected by the presence of fentanyl. He remained in state custody about 16 months later, I believe to be precise 495 days later when the termination hearing began. Of those 495 days, the case, you could almost think of it as having progressed in thirds. There was about a third of the case at the beginning where the mother did not appear to be engaged in services, and I think she acknowledged there was ongoing use. There were, I believe, 172 days of the 495. I think it's about 34% of the case where she was in services. There was 2 days at Crossroads. There was a period of time at the Infinity House. There was a period of time at Enso Recovery. I think to be precise, it was 101 days at the Infinity House. It ended with her arrest and reincarceration at York County Jail. And I think in the run-up to the trial, that last 69 days leading up to the trial, she was at Enso Recovery in Augusta. And so we had the engagement in services coming in fits and starts. But we had this child who, from the day of his birth, had been in state custody, placed in a loving pre-adoptive home with a relative, cousin of his father. And so that's what Judge Moskowitz was weighing. We know in child protection proceedings that the parent's right to family integrity under Section 4003 of Title 22 is limited by the child's right to be free from abuse or neglect. And we know that the judge is tasked with hearing both sides' factual accounts of what's happening and making credibility determinations and weighing out the competing interests, are mindful of, on one hand, the amount of time it might take to make progress on these issues, and on the other hand, the reality that to a child who's been in state custody from the day of his birth, there is this need for this sense of permanency, this sense of, where will I be laying my head down on the pillow at night? And so there was evidence from a witness from the treatment court program that the mother was engaged in that I think is crucial to understanding time frames in this fact pattern and whether a fair amount of time was given. The mother was participating in the treatment court, having been convicted of trafficking. And her witness from the treatment court mentioned that at the time of the termination hearing, she had recently made it to the second of the 5 phases of that treatment court. She was about 12 months in, and most people completed that program.
Are you saying, well, if we have a really strong case, we don't need no guardian ad litem?
No, I'm not saying that. What I am saying is that this child shouldn't be prejudiced by any deficiencies in the performance of the judicial branch appointed guardian ad litem.
How do we deal with that? I mean, if we have a really deficient performance by a guardian, I mean, whose responsibility is that? How do we deal with that? It's really not okay.
No, everyone should be held to a high standard in these matters. It's important. And if DHHS is ever aware of an issue, they should bring it to the court's attention. The way a guardian ad litem comes into a case, of course, is appointment by the judicial branch, payment by the judicial branch, receipt of reports by the judicial branch. But certainly, if the executive agency, the Department of Health and Human Services, is aware of an issue, they should bring it to the court's attention. So let's review this guardian ad litem's performance. As my friend indicated, there was only one report filed. I have, I think, a different understanding of some of the aspects of that report. There was a suggestion that it was for, quote, the father's jeopardy hearing. I don't know. It indicates that the persons interviewed were the mother, the foster mother, the department's caseworker, and 2 more people, the case manager who worked with the mother at the Infinity House in Bangor, and the case manager at Enso Recovery, this facility in Augusta that the mother was, at that time, gearing up to leave the York County Jail and enter that facility. So there were a significant number of mother-centric witnesses interviewed by the guardian ad litem in the course of preparing this report, and it listed the 5 different occasions to that date that the guardian ad litem had met with the child. Question of records was raised. It sounded almost as though perhaps there was a feeling that the guardian ad litem had access to records that the guardian ad litem was not reviewing. I'm looking at page 16 of the second day's transcript, and we have, starting at line 14, the guardian ad litem saying, "I'm upset that we don't have any of the drug screening results or any records from Infinity House or Enso Recovery. But we've gotten enough through family team meetings and emails to know that there were some pretty serious concerns at Infinity House." So the question on record review, I don't think the record supports an allegation that this guardian ad litem wasn't reviewing records that were made available to her.
Do your records show that she was attending the family team meetings?
So the transcript, the trial transcript, reflects that her attendance was mixed at family team meetings. There were family team meetings she attended, family team meetings she did not. I think the caseworker scheduling these...
There's no question she wrote only one report.
That's true.
The date of that report is February 2024, which was after the Jeopardy hearing and several months before the TPR hearing. So it was prepared somewhere in connection, maybe, well, I don't see a judicial review on record for that.
It looks like it was dated the date of Dad's Jeopardy hearing, which was also a judicial review.
Okay.
And she said on the cover in the caption.
It's typical, guardians prepare reports, don't they, for the summary preliminary hearing sometimes, certainly for the Jeopardy hearing of both parents, for the TPR hearing. The department is aware of what's happening. Was there no attempt to bring this to the court's attention?
The record doesn't reflect what sort of internal discussions there were about that, because this is not an issue the parties deigned to litigate at this hearing. No one objected to the admission of this report. No one made a motion to say, we need a different guardian ad litem. The parties took the guardian ad litem at face value and exercised their prerogative to cross-examine her on this issue.
Let me ask about the drug court treatment. You said she was in phase 2.
Had just begun.
Had just begun phase 2 after what period of time?
About a year,
Okay.
June to June.
All right. It's not unusual for drug court participants to take a while to get going and to the typical time to get through a drug court program. The fastest you can get through it is typically 18 to 24 months.
This record says something different. I'm working off of this record, which says in this program the fastest was 13 months. Most people did it in 15 to 18.
Well, that may be this record, but when I sat on the drug court, that wasn't my experience.
I don't know what to do with that, Your
13 is the
Honor.
absolute quickest you can get through it. That is true. But many participants take much longer than 15 to 18 months.
I will take your word for that. Working off of this record, we had a witness from the treatment court program explain that you could make it through the first phase as quickly as 30 days. Each of the 4 successive phases would have been a minimum of 90. And we knew that about a month pre-termination hearing, the mother had made it into the second phase.
That adds up to 13 months at a minimum, I think, if you say, to get through all 4 phases.
That's true. Yeah. That's the fast track.
Yes.
And so the fast track is not the standard I want to hold her to. I'm interested in this treatment court witnesses' testimony that most people in that program, self-selected program of people with serious issues they're working on, most people in that program complete it in about 15 to 18 months. The mother would have been on track to complete it. She had begun it June 23rd of 2023. And she wouldn't have been on track to complete it at the time of the termination hearing until much, much later than that schedule, as that witness indicated.
But wasn't the schedule, I mean, in this case, and I think we didn't have a chance to hear much about this from Attorney Murphy, but isn't one of the issues here that what we know about recovery from opioids, more not so much from necessarily other kinds of drugs, but is that it's a lengthy process, and for example, the statutory presumption of 9 months is really actually quite unrealistic. You can't make it through the treatment program in less than 13 months, and that's the criminal court. Isn't that a problem that we should to hold people who are in recovery to essentially, I mean, didn't the judge in this case essentially hold her to an unrealistic standard?
No, and we know that because of those numbers from the treatment court witness who said most people are on a much faster pace in that
They
program.
are, but in this case, for various reasons, like failing to appear in drug court, she ends up being jailed for fairly significant periods of time. Significant in the context of reunification, I should say, more than once, right?
That's true, jailed more than once. I don't take the position that there are easy answers in this area of the law. You have competing interests. You have competing parties, each of whom are entitled to great respect. This mother's battle with substance use, progress in fits and starts toward recovery is to be applauded. I think everyone in this room is rooting for her and was at the time of the trial. The fact of the matter is, there's also another person with a stake in this case. That's a person who was born, entered state custody the day of his birth, and has been awaiting permanency for an extraordinary period of time.
It does sound like what we're saying, though, is at least speaks to what I understand. It doesn't help in this case, but an impending pilot in Augusta District Court to integrate the treatment court, how we handle these cases and the like, to make sure we're not in conflict with the goals of, for example, a criminal drug court versus family reunification. There are competing interests, but that maybe they have to at least be dealt with in the same venue.
I think you're right. It's important to be sensitive to those issues. You think about the way our government is organized. The legislative branch has a fact-finding process it can go through, holding hearings, making decisions about whether there need to be adjustments to the statutory framework. Today, in this forum, in this courtroom, looking at this fact pattern, the existing statutory framework, decades of case law, the position the department is taking is that Judge Moskowitz issued a legally sound judgment.
Did he rely on the guardian's recommendations in this case?
Not expressly. As Attorney Murphy was arguing, I was reviewing the order one more time to be certain of this, and I don't think he expressly talks about the guardian ad litem. Certainly he would have heard her make her recommendations. Certainly he would have heard her be cross-examined by the mother's attorney on the issues with her performance. No one filed a motion for further findings asking him to kind of hone in on any guardian ad litem-centric aspects of his decision.
Can I ask you more generically about the guardian ad litem issue? The mother argues here, and I think I agree, that full-hearted participation of the guardian ad litem is not optional. It is, not only is it required by statute, but I know when I did them, which was 32 years ago, but I did rely heavily on that because the guardian ad litem is a quasi-judge who gets to actually go into the home and actually see things there. I found it absolutely invaluable. And when we have a guardian ad litem, theoretically, who's not doing the full process we're expecting, if the judge lets that go by, and as the judge is basically saying it's not really all that important to me, but for me, it was terribly important, I would have been the one who would have been jumping in saying, I need you to do this and that. So here's my question I'm finally getting to, is the fact that that didn't happen here suggests that the judge was not feeling any particular loss of a resource. The judge was comfortable with the guardian's performance or lack thereof in that instance, because I think it would be the judge in the first instance who would say, I need more from you.
What I take from the record is that Judge Moskowitz was comfortable that a full, thorough trial had been conducted, given that, comfortable issuing a decision. No party made a motion saying, given the lack of reports filed, therefore this relief must be accorded. We don't know for certain how he would have responded if someone had taken that position. No one did. This child shouldn't be prejudiced by the deficiency of the guardian in not filing as many reports as she should have.
Or doing an appropriate investigation.
Any deficiencies perceptible in the guardian ad litem's performance, I don't think the child should be prejudiced by those.
Can I ask you one more question? I understand we have case law saying so long as there is proof of one basis for parental unfitness, that is good enough. In this case, the court found 3 bases, including a lack of a good faith effort to rehabilitate and reunify. Do you believe that particular, I know given our case law it may not matter, but do you believe that that particular finding is well founded?
Yes, all 3 were supported on a clear error standard of review. You've identified the weakest of the 3. I agree with you about that. But all 3 were supported. And it doesn't need to be reached, the good faith issue, because the first 2 were supported.
I understand that.
Thank you.
Thank you. And Attorney Murphy, you reserve 3 minutes for rebuttal.
Thank you, Your Honor. I do want to note one thing with respect to the release issue that was brought up by my opposing counsel here. It's true that the guardian ad litem spoke about the records at Infinity House and Enzo House. There's also testimony at page 155 of the transcript, which was the Enzo House licensed clinical social worker with over 20 years of experience, who testified that there was an active release in place with respect to the Enzo records. The guardian just chose not to look at them. And so I just want to make it clear that this was not a failure of the mother to sign the appropriate releases that she needed to give the guardian full access to her medical and treatment provider records. It was a fact that the guardian didn't take the opportunity to review them, which she was obligated to do under Section 4005.
Was the guardian's deficient work in this case brought to the court's attention? I was looking at the judicial review orders. I note that the guardian was absent on occasion, but I didn't see anything else in any of those orders talking about problems or deficiencies in the guardian's performance.
I have not seen anything in the record either, Your Honor. Again, I submit that that is not necessary, that the court could not have made this best interest determination absent a thorough and robust investigation by the guardian ad litem. And I certainly don't believe that it was on the parent's attorney or the parent to bring this deficiency to the attention. If anything, I think it should have been on behalf of the department. That should have been their obligation to ensure that the guardian was doing their job, or the court should have ensured that the guardian, as an agent of the court, was doing a robust investigation, as Justice Meade noted, so that they could comfortably rely on an informed investigation when severing a fundamental right to parent a child, particularly in these circumstances, Your Honor.
Did I understand you to say your view is that the court is not able to or may not make a best interest determination absent a guardian ad litem's input?
Absolutely, Your Honor. That would be my position with respect to this case under 4005.
And
that is, the
think,
guardian is mandatory in these cases.
Well, I know the guardian is mandatory, but does that mean the court can't make a finding based on other evidence?
It can make a finding based on other evidence, Your Honor, but it has to have an informed recommendation based on an investigation of the guardian in order to come to a best interest determination. And if there is no investigation and thus informed recommendation, it cannot make a adequate, constitutionally sound best interest determination.
So the court can't waive it? The court can't say, don't have a report from the guardian ad litem, but I don't need it. I've got all the evidence right here. The court can't do that?
If there's some other evidence of a robust investigation in the record, Your Honor, I think it could. In these circumstances, that did not exist.
Aren't there other remedies available? I mean, in the statute, I understand it's mandatory, but the statute doesn't say, and therefore you can't terminate parental rights. I mean, there are other remedies available for the guardian's dereliction of duty, assuming there is some, including a report to the guardian review board and removal, correct?
That is correct, Your Honor. Yes, and I'm not disagreeing. I do just want to note one more thing, if I may, Your Honor.
Sure.
Attorney Humphrey mentioned that, everyone should be held to a high standard. I just want to note that in this case, the guardian ad litem was not held to a high standard. DHHS did not meet its obligations under 4041. The court got the facts wrong, and in the face of all of that, there's nothing to suggest that the court did not find the mother credible, and she was engaged in services at the time of termination. And thank you very much, Your Honor.
Thank you. As is our usual practice, we will take this matter under advisement. I will note in open court the request to have this matter heard on oral argument, and I will note that the court was persuaded, amongst other reasons, to grant that request because the court is very grateful to Attorney Murphy's efforts in these cases, and I want to say that publicly.
Thank you, Your Honor.
Thank you. With that, the court will be in recess for the day.
All rise. All persons having anything further to before the Honorable Justices of the Supreme Judicial Court, sitting in the law court may hence depart due to their attendance here at 9:50 tomorrow morning, as this court now stands adjourned. God save the state of Maine and this honorable court. Pleasure as always. Y'all have a great